Good morning. Welcome to the First District Court of Appeals. We have 3 cases to be argued this morning. When I call your case, if the attorneys would please stand, state your name and your readiness to proceed. The first case we have is C-24-0439, Lyles versus Sporing.
Good morning, Your Honors. Joel Buckley, counsel for Appellate Lyles.
Good morning, Your Honors. May it please support Lisa Hayes. I'm appearing on behalf of the defendant, Napoli, Richard Sporing, and we're ready to proceed. Thank you.
The second case we have on the docket this morning is C-24-0332, Geico General Insurance versus Soleil Fala.
Yes, Attorney Darren Kiefer here on behalf of Appellant Geico, and we are ready to proceed.
Good morning, Your Honor. Mohammed Hamadullah, attorney for Appellee Fala. We are ready to proceed.
Thank you. And the third case we have this morning is C-24-0316, State of Ohio versus Gail Watson.
Jennifer Bishop for the City of Cincinnati, ready for argument.
Eric Larson on behalf of Gail Watson this morning, ready for argument.
Great, thank you. All right, we will begin with C-24-0439, Lyles versus Sporing. Mr. Buckley, you may come forward. Would you like to reserve any time for rebuttal?
Yes, Your Honors, I'd like to reserve 3 minutes for rebuttal.
All right. You may proceed when you're ready.
Good morning, honorable judges of the First District. Thank you for taking your time to spend listening to this argument on appeal. What this case boils down to is that Sporing is trying to create an automatic dismissal on the merits when service has not been obtained within a year and the statute of limitations has run. Sporing wants to forgo a requirement to actually obtain a dismissal or a judgment on the merits. That's why Sporing does not discuss Freisinger at all in their appellee brief, because Freisinger says that a voluntary dismissal under 41A is not on the merits. Not being on the merits is necessarily fatal to Sporing's argument, because therefore Moore does not apply because the steps of the saving statute were met. Under the 2004 amendments, the plain language of the saving statute requires that the new action to be filed within 1 year of the voluntary dismissal or the original applicable statute of limitations, whichever is later. In this case, it was filed with the appeal, or the saving statute second complaint was filed within 1 year of the voluntary dismissal. The Ohio Supreme Court, like I said in Freisinger, ruled that the 41A dismissal is not on the merits. The Able Court found on points with the facts of this case that the 1 year time period permitted for refiling under the saving statute is triggered by the trial court's order of dismissal, not the anniversary date of the filing of the complaint, where there has been a failure to commence the action under 3A.
Counsel, your opponent argues that it's significant that the statute of limitations period ran during the first action. Can you address whether that matters at all?
Doesn't matter at all under the saving statute. The plain saving statute does not require that service has been perfected. That's why the courts have all held that there is only an attempt to commence. Rule 3A, while I understand why they tried to argue it, just like the Moore court did, Moore does not apply here. If you apply to the facts, let's look at Moore. Let's jump ahead to Moore. If you look at the facts of this specific case and apply them to Moore, even the Moore court would agree that their holding would not apply.
And does it matter that the 1 year for service under 3A ran out? Is that significant?
Again, under Thomas and all of the cases applying the saving statute, no, it does not.
But what about under the language of Moore, though? I mean, Moore seems to indicate that, with regard to the dismissal, otherwise on the merits, it needs to be before the 1 year runs.
Again, that's only, Moore does not apply where the saving statute does apply. That's the whole interplay here. Because Moore specifically held that the saving statute did not apply. They were explicit in that holding. And if you go to paragraph 30 of Moore, they explicitly says the saving statute only applies when its terms are met, when an action is commenced or attempted to be commenced. Here, the action was attempted to be commenced. Next, under the saving statute, when a judgment is reversed or action fails other than on the merits, that is, when there is either a voluntary dismissal under 41A, here. And then finally, when the complaint is refiled within 1 year, here. Now, to your point, going back to the whole 3A requirement, that's not what it says. The savings statute requires the dismissal to come in due time. It does not require within 1 year. If it required within 1 year, that would take us back to pre-Thomas, and that would take us, it would be superfluous. The in due time language would be irrelevant if it was read that the service had to be completed within 1 year. Now, the
I
main.
think, Counsel, can you help me with something? I'm following your argument logically with the plain language of the statute. But I suspect that your opponent is going to say that none of that matters because both the statute of limitations ran out and the 3A service timeline ran out. And that means that we stopped having an attempt to commence a lawsuit. And what we had was a lawsuit that basically failed for its statute of limitations at that point, and therefore there's a merits-based dismissal. Can you explain to me why that's wrong?
Because there was never dismissal, merits-based dismissal entered by the court. They filed for one, but the court never entered it. The 41A voluntary dismissal was filed first. Under Freisinger, that is a dismissal not on the merits. More cannot apply because there was never a dismissal on the merits. The saving statute has to apply because there was never a dismissal on the merits. What Sporing is trying to do is trying to read what I stated at the beginning. They're trying to read an automatic dismissal on the merits after the 1 year period for service
And so
expires.
is it correct then that we look at what actually occurred in the case under your position, which would be the 41A dismissal, rather than the timelines and what could have happened in the case?
So the big distinction between here and Moore, to your point, is that in Moore, they never 41A'd the case. There was never a dismissal other than on the merits. What happened was the 1 year period expired, then the other parties moved for a dispositive pleading, which the court granted. You had a dismissal on the merits. Again, this is highly distinguishable from Moore because the saving statute applies by the plain language. There is no argument that the plain language of the saving statute was not met here.
And so is this more like McCullough then?
This is a lot more like McCullough, and McCullough does a good job of discussing the 2004 amendments and why the logic of this case, even though, again, the big distinction here is they had the grounds to have the case dismissed when service was not commenced within 1 year. We're not disputing that. But the dismissal was never entered. The dismissal on the merits was never entered by the trial court. The only dismissal that has been entered by the trial court was a voluntary dismissal, which under Freisinger is not on the merits.
So they were litigating the case, waited till the statute of limitations ran, and then filed their motion to dismiss, right?
Correct, yeah,
Which is apparently fine under the case law.
I don't believe so, but I mean, again, I think, courts have said, yes, I guess if the court would have granted in this case their dismissal, we wouldn't be here,
So you all then beat them to the punch and filed the voluntary dismissal before the court could rule.
which is what the civil rules allow and what the saving statute allows. That's the whole purpose of the interplay between the 41A voluntary dismissal and the saving statute to allow for potential procedural deficiencies. That's one of the reasons.
But I think like what I had asked you before, and then looking ahead at the McCullough case, it was kind of interesting in the McCullough case because they do talk about the plain language of the saving statute applying, and then they say the second complaint was dismissed without prejudice within a year of being filed. So again, they use this language that somehow this dismissal, this voluntary dismissal has to happen within that 1 year service timeline.
There's no plain language requirement for that. There's no statutory requirement for that. There's no judicial requirement
Would
for
you
that.
agree, though, that Moore and McCullough seem to suggest that?
No, because the statute plain language reads in due time. If you were to make a 1 year
I'm sorry,
requirement
I'm
on
talking
that-
about the language in the cases, though. You don't think that the cases seem to suggest that this voluntary dismissal should have happened within that 1 year timeline?
Again, I read that as the court saying that a dismissal on the merits could be entered at that time period, but they weren't. So it could be, just like I'm saying here, it could have been, in fact, Sporing tried to, but again, what happened here was the voluntary dismissal was filed first. And again, to take that reading of it would render the in due time plain language of the saving statute superfluous. Because every court has held, it is not 1 year of refiling from the running of the statute of limitations when it expires. It's 1 year from the dismissal time. So inherent in that was consideration that a dismissal could be filed voluntarily after the statute of limitations had run. Otherwise, it would not read in due time. Any other questions, Your Honors? All right, thank you.
Good morning, Your Honors. We are asking that you all affirm the decision of the trial court, which found that the plaintiff appellant's claim was time-barred, based on the decision in Moore. And we maintain that the Moore decision is basically a roadmap for your analysis here, because, Your Honor, I think you hit the issue on the head. You hit the nail on the head, which is the dismissal has to come before the statute of limitations expires and/or before that one-year period to commence expires.
What in the statute tells us that?
The saving statute?
Yes.
I think, okay, I'm happy to answer that, Your Honor. The saving statute has basically two things that it requires. Number one, it requires that the plaintiff commence or attempt to commence the action. We don't dispute that the plaintiff appellant in this particular case attempted to commence his action. But the plain language of the statute requires that the action fail otherwise than upon the merits. Where a case has not been filed within the statute of limitations period or timely commenced under Civil Rule 3A, it fails by operation of law. It fails on the merits because that limitation period has not been satisfied. And that was basically the crux of what Moore was saying, and what was basically
And so your
applied.
position then is we're to look beyond the 41A dismissal at the timelines that occurred?
Right, exactly. So let's kind of talk about the story of this case. And I think it's important to mention, the original docket was not asked to be transmitted for the purpose of this appeal by the appellant. And I think it's important too. I want to go back and answer your question about run through the timeline of this
So
particular
actually,
case.
wait, that's an important point. So let's
is.
pause there.
Yeah.
So the 41A dismissal, is that in the record?
It is in the record of the original action. But what the appellant failed to mention is, once we were able to file our motion to dismiss based on the failure to commence this action within the statute of limitations, we filed that motion, and then the 41A came.
But the trial court didn't rule on your motion.
Correct, it did not.
So
But-
that is a denial then. If the trial court, but it's implied or it's assumed that if a trial court does not rule on a motion, it's considered denied, correct?
Well, I don't know. We never got a chance the trial court never got a chance or did not rule on the merits for whatever reason. Trial courts hold on motions, but
But and then going a step further, doesn't the case law say that a 41A dismissal is other than on the merits?
absolutely. That's what Freisinger said, and I don't disagree with that. But a 41A is not a panacea for saving a claim that's already expired by the statute of limitations.
So under your argument, it's possible that in some cases, a 41A dismissal, if timely, if within that time period, could trigger the saving statute.
Absolutely, and I think that's what Moore stands for. I think that's what the Supreme Court was saying. There's a roadmap for the plaintiffs. It is, if you are not able to obtain service within 1 year and your statute's running, you have that tool in your toolbox. You can go file a 41A, and then it's a dismissal on the merits, and you can file within 1 year because your claim has not failed.
But the 41A doesn't have to be before the one-year timeline. It would only have to be before the statute of limitation.
Yes, you just have to have some basis to save your claim at the time you file your 41A. Either you have time left on your statute of limitations, or you have time left within your 3A 1 year. But when both of those expire, which happened in this case, that's when a 41A does not matter.
And how do we know that? I just want to clarify the status of the record here.
Sure.
How do we know that both of those timelines have expired if we have nothing in the record from the first case?
Well, I would say because in the record of this case, all of those dates have been verified and not, have not been objected to by the appellant. And so anything that we've maintained and relied on in, to obtain our summary judgment has been waived. I think it's in the record of, those dates are in the record of the case because of the motion practice. The record itself in the original case was just not transmitted.
And the trial court's order, if I recall correctly, has that chart with the dates and things.
It does, Your Honor, yes.
And do you dispute any of those dates?
I don't. None of the dates have been disputed. I think the parties agree on the dates. We're just disagreeing about how Moore is applied to this particular case.
So you're arguing that if the statute of limitations runs, then they're done. I mean, it seems to me, though, that a statute of limitations is actually an affirmative defense, right? It's something that can be waived. So I'm a little bit confused on how we just get to this automatic, it's over once it's beyond the statute of limitations.
Sure. I think, and I'm happy to answer that in two parts. The
Okay.
first is, it's not just the statute of limitations alone. It's obviously the interplay of Civil Rule 3A and being able to commence it within 1 year. Because if you obtain service within 1 year, your date of filing is, your case is commenced on the date you filed that complaint. That's what Civil Rule 3A says. Okay. So it has to be the interplay of both of those, Your Honor. I agree with you. It can't just be the statute of limitations. Now to address your point about the it being an affirmative defense. That was raised by Judge Stewart in her dissent in Moore. And it was addressed, I think, fairly cogently by Justice DeWine, who wrote the majority opinion in Moore, that no, we have to look at the fact that it is up to the plaintiff to commence his or her action within the statute of limitations and to comply with Civil Rule 3A. If you don't do those things, your claim fails as a matter of law, as an just because you can't
So
revive
you're
your
saying
claim.
Justice DeWine said it's not an affirmative defense?
Correct. I think
Okay.
you'll see that he speaks to Justice Stewart's dissenting opinion about that.
So
and
in the
flushes
future,
that
this is
out.
something that can't be, like, it doesn't get waived. If the defendant doesn't bring up statute of limitations, it doesn't matter.
It could be waived, you're right, but we didn't waive it. We pled insufficiency of service. And also, I think it's important to say, because I think there was a question posed to opposing counsel. Yes, we participated in discovery. That's what, up until the point we could file our motion. But we're permitted to do that under the Supreme Court's decision in Glizzo. As long as you preserve, because of that affirmative defense, we're still good. And that's what we should do, right? We should be able to participate, defend ourselves, and until, something presents itself like, hey, this case was not timely filed and it can't be revived. So I'm happy to answer any questions
Yes,
that you have.
one more question.
Sure.
What about the argument that your opposing counsel is making, that McCullough says the starting point is the plain language of the statute? And if we look at the plain terms of the statute as the starting point, we get to a very different place than if we look at the record and the dates and what happened. Can you address how McCullough might modify your argument?
Sure. I don't think that McCullough does modify my argument because the plain language of the savings statute, again, has two requirements, that you attempted to commence and that your action has not failed otherwise than on the merits. Now, it does not say the court says your case has failed otherwise on the merits. It says your case can't fail otherwise on the merits. A case that has not been timely filed within the statute of limitations has already failed on its merit. It's failed by operation of law. It's as if,
Is there any case law that you can point us to that says that we should look beyond a 41A dismissal and treat that as being on the merits when the record suggests that there's some sort of service failure?
I think that's absolutely implicit in the Moore decision, if you read it. I think because the court said, once the applicable statute of limitations expires, the savings statute cannot be used to revive an action that was not timely commenced under Civil Rule 3A. Those are the facts we have here.
Well, in Moore, though, there wasn't the dismissal, the voluntary dismissal, correct?
There was not a voluntary dismissal.
So the
correct.
language, so any language that would apply to cases that were voluntary dismissed, isn't that dicta?
I don't think so. I mean, I think the holding of Moore has to stand that you can't use a voluntary dismissal to correct a case that's already failed on the merits and under an operation of law. And so let me just be super simplistic about this. Let's say that the statute of limitations in this case was today. And the appellant doesn't file his case until March of 2025. And I go file my responsive pleadings, I put all my appropriate affirmative defenses in there, and then I file a motion to dismiss based on the fact that he has failed to file within the statute of limitations. And then before the court, the 28 days he has to respond, he runs to the courthouse and files a 41A. Does that have the effect of saving his action? It absolutely does not. And it's the same result in this case. That's our position, and we hope that you all apply more and affirm the decision of the lower court. Thank you, Your Honors. Unless you have any other questions for me.
Thank you. You had 3.5 minutes left in your initial time, so I'll give you 6.5 minutes if you want to take it.
Your Honors, I'm not going to need that long, I promise. Just a couple points. Relating back to the savings statute, when applied, again, when the plain language is met, it relates back to the original filing date. So again, any sort of statute of limitations, it would relate back to the complaint that was timely filed, the one that was attempted to be commenced.
Can you address the hypothetical that your opponent just raised, the one where the original action was filed outside the statute of limitations?
Sure, the original action was never timely filed. That's like the Smith case.
What in the plain language of the savings statute would prohibit that kind of filing?
In the savings statute, well, there was never an original action that was timely commenced, but the savings statute by its plain language requires a timely filed original action. In that hypothetical scenario, there was never a timely filed original action. By its own plain language, the savings statute couldn't apply. Going back to the 2004 amendments, all of the case law before the amendments, it all talks about a requirement that for the savings statute to apply, the action needed to be commenced. It needed to be served within 1 year. That used to be the requirement. 2004 amendments come, it was stricken, right? Like the General Assembly, all the courts since then have all decided it's no longer needing to be commenced, it's attempt to be commenced. Under the 2004 amendments, this is from the McCullough case. The plain language of the savings statute requires a new action to be filed within 1 year of the voluntary dismissal or the original statute of limitations. It does not say it needs to be filed within 1 year of the original filing date, which would be the 1 year commencement period that counsel for Sporing is trying to push. I cannot stress enough that there is no case law for their position that there is an automatic dismissal on the merits when the 1 year commencement period expires.
They're saying that's what Moore stands for.
That's not, what Moore stands for is that dismissal that was later filed, that motion to dismiss, became grantable because the 1 year period, commencement period had expired. The court entered an affirmative dismissal order dismissing that case. I'd argue, and I think the Moore court would agree, that had a 41A dismissal been filed before the trial court could enter their dismissal on the merits, then then they wouldn't be there because the 41A would have been filed first, the plain savings statute would have been met, and even if you look at the appellate court in the Moore decision, it sort of talks about that. I didn't really cite to that, obviously, because it got overturned by the Supreme Court, but even the appellate court in Moore talks about, you know, there's other considerations here. But again, the difference here is there was a 41A, like Moore, this case became dismissible after the 1-year period came and went, and there was no service, but there was no dismissal entered on the merits. Therefore, it is wholly different from Moore, and because the dismissal was other than on the merits, because there was a timely filed original complaint, and because the dismissal, or the new complaint was filed within 1 year of the voluntary dismissal, the plain language of the savings statute, all 3 requirements were met, and the trial court's order should be overturned.
Can you address the record briefly? What is in the record with regard to these dates in the first action?
Honestly, Your Honor, there's no disagreement. Parties are all in agreement about when the original complaint was filed, the argument, you know, when the statute of limitations would have run, it's not our position there were any extensions for COVID or anything. Like, the timeline as laid out by appellee, like, there's no disagreement. It just,
And the dates in the trial court's order are correct from your perspective?
yes, Your Honor.
All right, thank you.
And then just, so I know I keep harping on this, but I'm looking at the conclusion, or paragraph 36 of Moore, and it says, when a plaintiff attempts to commence an action but fails to obtain service within the Civil Rule 3A's 1-year commencement period, and the action has neither failed other than on the merits during that 1 year, i.e. been dismissed without prejudice nor been refiled, the plaintiff cannot use the saving statute to revive the action outside the limitations period.
Correct, but then it goes on to say that by its own expressly in that conclusion, the saving statute does not apply. The saving statute would have saved the 3A argument. That's our position, is that the saving statute obviates the 3A requirement. Otherwise, the saving statute wouldn't read in due time. It would read within 1 year.
Okay.
All right, thank you, Your Honors.
Thank you. Thank you.
Thank you for your argument. We will issue a timely written decision. All right, the next case is C-240332, Geico Insurance versus Fala.
Darren Kiefer, Your Honor, for appellant. I'd
Good
like to
morning.
reserve 5 minutes.
You may. Give me just 1 moment to get our timer set up. All right, you may proceed when you're ready.
May it please the court, thank you, Justices, for hearing this case. I'm going to do something I usually don't ever do in oral argument, and that's going to start with the last argument in our brief and work backwards, just because I don't want it to get lost in the shuffle of how this case was decided by the trial court, and I think it's something interesting that this court needs to look at, and that is the question of excusable neglect. Did the trial court actually find excusable neglect? In the affidavit that was presented to it to get the motion to the hearing stage, the appellee stated in paragraph 4 of that affidavit, received a certified mail document from the trial court. He got the complaint. He was actually served. In paragraph 10 of that same affidavit, I believed it to be a scam and I did not take any action. Excusable neglect is not meant to excuse a defendant getting a certified mail letter from a court and doing nothing with it. If that were the case, every one of my default judgments that I get across the state of Ohio would be void or thrown out every time, because everybody can come in and say, I thought it was a scam. I don't know about you. I get lots of email scams. I get lots of clearinghouse scams and publishers clearinghouse mail. I don't get any of them by certified mail, especially not from the
I'm
clerk
actually going to
reports.
redirect you for a second.
Sure.
Sort of.
Okay.
So is there any dispute that that Mr. Fala called counsel for Geico?
No, that would be me. And no,
Okay.
there is no dispute on that.
Okay, and what was the timing of that?
That was in the summer, so none of this is in the record because we were not able to put any evidence in the record.
Was that an admission, though, during the hearing?
No, there was, I mean, I admitted that that he called me, yes, that part, but that's still not evidence. It's still a statement by counsel in court, but it's not technically, under the evidence rules, evidence before the trial court. But yes, that was in the summer of 2023. I spoke to him and his daughter.
So does that make a difference?
To me, it does, because at that point, he knew about the case. He clearly, at that point, that would be getting to the timeliness of their motion to vacate the judgment. I mean, they knew about it in June. We corresponded in June and July of 2023, and then in March of 2024 is when they sought to undo the judgment. So they knew that the case had been put in a judgment situation for nearly 8 or 9 months, but took no action with it again.
Counsel, did you
Yes.
preserve any objection to this? I noticed there wasn't a written response filed to the 60B, and
That's a great question, and to answer your question, I've actually stopped filing oppositions to 60B because 9 times out of 10, the courts will set them for hearing. And so rather than alert opposing counsel as to the arguments we're going to raise and have the court still set it for hearing and give them the opportunity to prepare to, address what I'm going to argue, I'd rather show up and ask the questions of the opposing party on the record to get them on the stand. So in this case, for example, in the affidavit, had we been able to actually inquire of the defendant,
well, did you object on the record or take any action to try to preserve arguments at the hearing?
I don't know that that's my obligation in the 60B arena.
Why not?
Sure, because the burden of proof is on the appellee at the 60B hearing. They have the evidentiary burden, I do not. My job is simply to poke holes in what evidence they present. It's not my job to assert a case, and that's why I think part of the trial court and appellee's counsel both assumed that it was my obligation as the counsel for appellant that got
But
the
if you want to
judgment.
preserve issues for appeal, you have to create a record of an objection.
Correct, but I would agree with that. I'm not going to dispute that part of it, but I don't know that creating a record for the objection of me saying there's no excusable neglect negates the fact that there was no evidence before the trial court.
Wasn't the affidavit evidence?
Well, if you look at the Supreme Court case law on Rule 60B motions, the affidavit is only there to get you to the hearing stage. Once you're at the
What
hearing
case
stage.
says that?
The Colson case
Doesn't it say that the court may,
should, not
should?
may, should.
Right, should and not shall?
Should, yes, not shall, not may, but it says that they should take evidence at that point, because at that point you give the opportunity to my side to actually question it and for the court to judge or adjudicate the truthfulness or the candor of the person making the affidavit, as opposed to having a written document before them.
Could the trial court have undertaken that function implicitly once I just want to walk you
Sure,
through.
no, I'm okay.
And you can feel free to
No,
tell
you're
me if you think my analysis is incorrect.
Okay.
Could the trial court have given some weight to that affidavit once you made the admission that there had been the conversation earlier about the scam allegation?
I believe they could. I'm not going to say they couldn't have given weight to that, but I don't believe that satisfies their 60B obligation. The 60B procedure is pretty simple. It's a two-step process. The motion gets filed, and if in that affidavit the 3 elements appear to be there via affidavit, then the trial court should set it for hearing to take testimony and gather evidence to make sure that when they grant that, they're entering a decision based on actual evidence and not based on a sworn statement that they've been provided in a motion.
What would be the difference in a hearing that with something like this and what actually happened? So let's say that Mr. Fala took the stand and all he said was, I signed the affidavit and everything I said in the affidavit was true.
Sure. At that point, then, Your Honor, I would get to cross-examine him and go line by line on that affidavit, which we were not afforded to. If you go strictly by the affidavit, due process gives the appellant in this case, or the plaintiff, no opportunity to challenge it.
And what would have then happened? I mean, where in the record did you preserve an objection asking to undertake that kind of cross-examination?
I think if you read the record of the trial transcript, other than about 4 lines of statement, I wasn't afforded much opportunity to argue at all. I mean, in this case, we were outside of the appellee's counsel talking with the court over whether or not excusable neglect was presented, I was, other than confirming that I did actually speak to them, and that we did not agree on the fact that the 60B should be done, I was given no opportunity or chance to even be heard.
And so it's your position that to the extent there's no objection at the hearing, it was because the trial court didn't afford you the opportunity to object?
Correct.
All right, thank you.
It seems, though, that what the court did here was just clearly based on the affidavit must have found excusable neglect. Now, I know that you're arguing she needed to make findings and whatnot.
Sure.
But, you know, you started off saying that the affidavit itself didn't create excusable neglect, which frankly I think is probably your best argument here because, you know, an affidavit typically is considered evidence. And so here we have a phone call to a lawyer, but the affidavit doesn't elaborate what was said, right?
Correct.
And so based on this affidavit, your argument is that that in and of itself doesn't amount to excusable neglect, right?
Correct.
And so it's their burden,
Yep.
and that's all that was in front of the court.
Correct.
Okay.
And my position is in the case law that we cited, the Suarez case, which is out of the 5th District, which I think goes through the 9th, the 12th, and the 4th District, all have said, look, that if a person gets confused over the allegations or is unclear as to what's being done, even though they're pro se at the time they're getting the complaint, that is not excusable neglect if their actions caused the delay and caused them to be in the position of having a default judgment. And I think the closest case that I provided with the court was the Globe case out of the 10th District, which was a similar situation. A pro se party got a subrogation action just like in this case. They didn't answer it. They were confused over what date they had to respond to the complaint, and then a default was entered against them, and they waited till after the default judgment was entered against them to seek counsel.
It seemed to me that there was, what I gleaned from this transcript was that the court had some concern because there might be a situation where this was not the proper defendant and they weren't involved in the accident at all.
Correct. That was their meritorious defense argument.
Right.
That is, and I, you know, it's the same thing like with, we had here a couple years ago with the Bronco excavating case that I cited to. I mean, the question is there actual liability on this person? That's a meritorious defense piece versus the excusable neglect was, did they know about the case and did they respond correctly or take action once they learned they were being sued? Whether or not they agree with the allegations, of course they did not. That would have been their defense to the case that it wasn't them. But that's not excusable neglect. That's simply going to a meritorious defense, to the other prong of the piece.
All right, thank you.
As far as the requirement of the GTE factors, I do think to address the court as to what the trial court has to find. I think the case law is pretty clear from this court, as well as other appellate courts, that a trial court does abuse its discretion unless it actually finds the 3 prongs of the GTE test were found. Yes, ma'am.
So the Carlson versus City of Cincinnati case,
Okay.
in that case, I believe our court said that the trial court does not have to make specific findings. Do you dispute that?
I do in this case because then I'm going back to the selective case, which is directly on point with a 60B motion and a subrogation file, where this court said that a failure to find all 3 GTE factors in their entry is, by its definition, abuse of discretion.
Did you ask for findings of fact?
I did not.
Okay, so the Carlson case suggested that if a party does not ask for findings of fact, doesn't file a 52 motion, then they're not entitled to findings of fact.
And is that a 60B case?
I believe so, yes.
Okay, I don't know, so
Okay.
that's why I was asking, Your Honor. So you got me on that case, because
Okay.
I don't know that case, but I'm just going off what the cases that I provided to this court have said, that if a trial court does not make specific findings of fact of the 3 factors of the GTE test, then there is no ability to grant it. I mean, we're here arguing we believe the trial court found excusable neglect. We don't know. Was it timely? We don't know. Was it, is there a meritorious defense? We don't know. We have 2 sentences. One in a written entry that says, for good cause shown, it's granted, and the other, well, if you're going to agree to disagree, I'm going to grant the motion.
What was the case that you relied on from our court that said you did need findings?
Selective Insurance Company versus Bronco Excavating from 22, I'm sorry. And it's paragraph 16.
Okay.
And counsel, you're out of time.
All right, thank you.
Good morning, Your Honors.
Good morning.
Mohammed Hamdou, attorney for appellee, Mr. Fala. First, Your Honors, if you see the motion that was filed initially was basically under the 60B rules, under the what's allowed per the 60B. You have mistake, inadvertence, excusable neglect, newly discovered evidence of fraud. At the time of the motion was filed, what was alleged specifically was under 60B, but more specifically stated the entire law with all of those requirements. And also, number 5 of that also says for any reason the court feels necessary.
And do we know under which prong the court granted relief?
Not necessarily, Your Honor. I think based upon all the totality of the evidence, the court listened, and my feeling is it's felt that a number of prongs were met. Not only was excusable neglect, but also fraud based upon the fact that my client was not involved in any accident. I think that was important at the hearing was as the court asked.
And could this also have been, let's say, a mistake?
A mistake, but my understanding, it could have been a mistake, but also as far as it being a mistake, I think that that's more of an issue with the fact that you put the wrong document, wrong information, maybe more so than a clerical error that goes further to a mistake, more so than something that is excused because of the default judgment that was granted. I know that seems a little complicated, but I think the issue here is, was this person really involved in this accident? However, when we got to the hearing, not only did opposing counsel not even file a reply brief to my motion to set aside to raise any issues or concerns, but did not, when the court asked, well, did my client contact you? He said yes, but also the most important thing was there an accident report?
Would you pause there? So
Yes.
what's the significance of the concession that in fact a phone call did happen? What do we do with that?
Yes, because that shows that my client did not just stand pat and do nothing. My client did receive a document and started to act based upon the document that it was received. And when we're talking about something that's completely out in left field, when you say, hey, I got something, I'm not even in an accident at all, I'm going to call somebody and see, what is this, what's going on with this? Not only did he do that, but he also sent the accident report from the accident that occurred several months prior to show that this car was already involved in an accident. And then when the judge asked opposing counsel, have you seen the accident report? And he said, yes, I've received it. I think that was enough for the judge to hear at that time. You knew there was an accident. You knew that these people were claiming that they were never involved. And I think more importantly, which I found out as we started proceeding and I got involved, that at the time of the accident, from the accident that they received a default judgment, there was no license plate number, nothing to link my client's vehicle. Several months later, they drive past and see a vehicle with damage on it and say, oh, let's go sue this
Well,
person.
and does the concession by counsel lend credibility to the affidavit?
Yes, I believe so. I think once he admitted that not only he spoke to them and also received this accident report and other information to confirm, I think what he did is to stand back and say, hey, maybe they won't do anything, maybe they will think it's a scam. Unfortunately, these scams have gone to several different levels these days. We have scams that go off that tell people that their warrants are issued for their arrest with the judge's signatures on these documents. So for him to call and then to say, hey, it's not me, you have the wrong person, then they do not hear back from the other attorney, for them to assume that this thing was gone away. The only reason why they were made aware, he was made aware of this whole incident, was that his license was suspended. He didn't know that he was even had a judgment against him.
And is that information in the affidavit?
Yes. the
That that's
affidavit.
what precipitated his knowledge of the suit was the license suspension?
Yes, Your Honor, it is included. And that's when he found out that his license was suspended, and at that point in time.
That's how he knew that it was in default?
Correct. On number 12, I was unaware of the judgment until I received a notice from BMV on December 13, 2023, that indicated that my license was suspended, and based upon that judgment against me. At that time,
And that's what would have been the trigger for him to understand it was real and not a scam?
Correct, and that's when he hired counsel. Unfortunately, his vehicle was in an accident in June of 2021. At that point in time, the vehicle was total disabled, could not be driven. They no longer paid insurance on it after that. He's alleging that the accident occurred in November, so his insurance company was not going to cover anything that occurred in November when his insurance was already canceled several months earlier.
Was there any objection placed on the record from your perspective, either in writing or orally at the hearing by Geico to your 60B motion?
No objection whatsoever, nothing raised. The only argument, first off, I believe that the court does not have to have a hearing in the first place. The court could look at the motion filed, read the affidavit, and grant the motion to set aside. There's opportunity for a response within the time to reply to the motion that was filed to set aside, and counsel did not file any sort of opposition.
Well, how does your affidavit, though, I get the meritorious defense
Yes.
piece of it, and
Yes.
that is very concerning, that your client might not have been the right person here.
Correct.
But how does your affidavit establish excusable neglect?
Yes, based upon the fact that there was contact made immediately.
But the affidavit doesn't describe the contact, right? It just says that there was a phone call made. Does it get into any more detail about what happened as a result of the phone call, or what your client was led to believe as a result of the phone call?
Yes, to a certain degree. It states in number 9 of the affidavit, we requested more information from the attorney to verify that this was not a scam, and we never heard back. Number 10, based upon lack of communication and complete unfounded allegation, I believe this to be a scam and did not take any action. Not only did you talk to him, they presented,
Requested more information
information.
and then didn't receive a response.
didn't receive a response, and gave him an accident report.
And could you explain to me how the request for verification and the lack of information back makes this the same or different from other cases where people were confused about court filings?
I think in certain situations where you may receive a court document and say, oh, this must be the wrong person, you just put it to the side, and then several months later bring it up and say, hey, I don't know what's going on. I think to receive a document and to say, hey, let me go and try to see what's going on with this document and verify it, I think those are the steps that are required, and I think those are steps that were taken. I don't think that my client stood pat and did nothing, actually tried to reach out and then did not receive any response. So unfortunately, should have paid out of his pocket. Normally, you would be able to contact your insurance company because of that lapse, the time between the accident and the terminated insurance and the point where he's alleging the accident. There was no insurance coverage from that time, so he couldn't have contacted, his insurance company was not going to provide an attorney to be able to argue this and dismiss this matter. So Your Honors, based upon the decision, the motion filed, which was pursuant to 60B, and I believe based upon the motion and the affidavits attached, that the motion was timely filed and the requirements were made, the court did grant the motion to set aside. We asked this court to uphold the actual motion and the decision from the lower court. I believe it was made, there were no objections made by opposing counsel, and I asked the court to uphold. Thank you.
Couple items to address back from the questions I had from the bench early on. So in the transcript record, if you're actually looking at the communication, if we're going to take my statement to the judge as being evidence in the record, then you would have to take as my statement in there. So when I questioned back to them, I'm reading from page 10 of the transcript, they gave an email from somebody else saying, oh, no, it was towed. But noting to the official report from the police agency showing the vehicle was drivable and left, as opposed to what they kept saying as far as the accident goes. As far as my sharing information with them as to what I did, I shared it with his daughter back in July of 2023 when they had contacted me. I emailed them a photo of my insured took of the vehicle involved and tracked down using the license plate and gave that vehicle identification of the license plate that they took so they knew as how we had tied them to this case. If you're going to take the evidence in the record clearly establishes that they got information back not only timely, quickly, and provided by me in email to his daughter.
What if we simply look at the affidavit and paragraph 9 discussing that they requested more information from the attorney and didn't receive a response? If we just look at that,
Still not excusable neglect. I
why
mean,
not?
because at that point, they've been sued. And the interesting part in this is if you look at the time frame of when they contacted me, it wasn't after they got the complaint. The complaint was served March 15th of 2023. They contacted me in June or early July of 2023, which was after the default judgment
Where do
was
we know
entered.
that time frame from?
the court record. He's-
How do we know when they contacted you? Where do we know that?
I just read it in my statement that I provided to the judge at the trial. I mean, that's the
No,
thing.
based on the affidavit, though.
Based on the affidavit, they just say they contacted me. You're correct, that you don't have a time frame in their affidavit.
Yeah.
But the question is, is this excusable neglect? I guess that's what I'm trying,
I'm looking at, did the judge abuse her discretion by finding what I presume here, we don't know exactly, but was excusable neglect based solely on the affidavit that was filed?
and I think therein lies the rub of this whole case. You just stated the entire case and the problem we have with it.
Right.
Is the judge didn't make any decision. We don't know what the judge found. You're making assumptions, I'm making assumptions, we're all going off the record, and that's why I cited the selective case. If you look at the paragraph 16 from this court just 2 years ago, says, and I'm quoting, "In the absence of any evidence in the record to support Bronco's entitlement to relief under 60B1, excusable neglect, the trial court abuses its discretion in granting the motion for relief from judgment." The court then cites to the case of Electronics Division versus Nail Frame, and in that quote cites their case saying, quote, "The trial court abused its discretion in granting the motion for relief from judgment in the absence of factual determination of the alleged grounds for the relief from judgment." That is the question. It's 60B. I know you're coming back to whether or not I have to raise an objection.
The syllabus in the Carlson case, which was, by the way, in 2024. So
Okay.
2 years after the case that you cited. The syllabus says that the trial court did not abuse its discretion in granting the defendant's 60B motion without an express finding of excusable neglect, because the trial court is not required to issue findings of fact and conclusions of law on a 60B motion where a party does not request them under Civ R 52.
Okay?
I mean, that seems to, I understand that you're
Yeah,
citing
so
a case from 2 years before
Yeah,
that,
so
but this
apparently
case
there's
seems to change that.
Yeah, I was going to say, now there's a dispute between this bench over how it's going to handle 60Bs, and does that overrule the other prior panel's determination?
Counsel, we'll read the full cases, and we have
Right.
read them. But the quote that you just gave to me doesn't, to me, create a conflict, because it was prefaced by the phrase, "without any evidence." And in this case, we have an affidavit. We don't just have a motion that was filed making some allegations without any proof behind it.
Same thing happened in selective. I was the counsel in that case. So that was my case. There was documents attached to the actual motion. It was similar to this case in that the court conducted an evidentiary hearing and took no evidence.
There was an affidavit attached to
There
the
was not an
motion.
affidavit. There were multiple documents attached to the motion to put into the record. It was a request to have it into intercompany arbitration. If you go back and look at that motion, there were 4 or 5 things attached to that motion. It was not an
But
affidavit.
no sworn testimony.
No sworn testimony.
Okay. All right.
Your time is up, but I'll let you make a concluding statement.
No, that's, it is our position that there is no excusable neglect presented in this case, even if you want to go on the affidavit, that simply misunderstanding what the complaint was is not equal legally excusable neglect when the defendant or appellant could have taken the action. And therefore, we ask that the court be reversed and remanded back to deny the motion.
Thank you.
Thank you for your arguments. We will issue a timely written decision. Our final case this morning is C-24-0316, State of Ohio versus Watson. Good morning.
Jennifer Bishop for the City of Cincinnati. The decision of the trial court
Ms.
must,
Bishop, would you like to reserve any time for rebuttal?
yes, 5 minutes.
Great, thank you.
The decision of the trial court must be reversed. The trial court erred when it granted the motion to dismiss. In this case, the defendant is charged with child endangering under the Cincinnati Municipal Code. The The trial court found that the Cincinnati Municipal Code child endangering section violated Revised Code 968, which states that the state law preempts any local restrictions on firearm possession, purchase, and storage. But shortly after the trial judge granted the motion to dismiss in this case, this court, the First District Court of Appeals, held that the Cincinnati Municipal Code child endangering section did not, in fact, violate the revised code section. This court, specifically in West versus the City of Cincinnati, says that the Cincinnati Municipal Code child endangering section does not mention or relate to firearms in any way, and it therefore does not conflict.
Counsel, that was a determination that subsection A doesn't present an independent conflict on its face.
Correct.
And it doesn't, because it doesn't mention firearms at all. But in this case, it appears that the city is trying to apply subsection A to firearms-related storage. So rather than having a potential facial conflict, which the court resolved in West, we now have the question of whether there's preemption as applied. Is there a problem with applying subsection A to the conduct that falls within the scope of 968?
Well, I don't think there is, and that is based upon lots of other appellate cases in the state of Ohio that say that how a firearm is used can in fact create a substantial risk of harm to the health and safety of a child.
But those cases all predate the passage of 968.
That's correct, but I also think that, well, actually, I don't know if they predated or not, but I do think that the factual determination, or a determination on the facts, I think every child endangering case you read says that it's a case-by-case, fact-specific determination, and in this case, there was no fact-specific determination. So I think it may have been a different issue if this was raised at Rule 29 or if it was raised as a proof beyond a reasonable doubt issue. But finding it as a motion to dismiss based on the complaint, I think the trial court erred and has to be reversed.
Well, do we have enough? I understand your point that perhaps we don't know what the facts are here, what the allegations specifically are until we have a trial. But the complaint itself alleges that Ms. Watson placed a loaded firearm, to wit, a specific 9mm handgun, under her pillow while her child was sleeping. So doesn't the complaint itself describe conduct that falls within 968? I mean, that statute addresses possessing, storing, or keeping any firearm.
But I also think that the totality of the circumstances and based upon the testimony that there could be other things that could present a risk of harm to the child that would be sufficient to sustain a guilty finding. So basing it upon the allegations in the complaint, I think the trial court erred.
So I'm trying to understand really the interplay between 968 and the child endangering statute that survived West. So under 968, a local municipality does not have the right to tell a parent, you have to store your guns in a particular way. Correct?
Yes,
But your
ma'am.
argument is, if you have a firearm that could be accessed by a child, even though we're not telling you you have to store it in a particular way, it can still subject you to criminal liability because you are endangering this child.
Creates a substantial risk of harm to the safety, health and safety of the child, and that is based upon the case law in the state of Ohio. So not based upon the statutory definition in the municipal code, based upon the case law in the state of Ohio. Correct.
But that case law predates 968. So what do we do with the plain language? Can you help me unpack the plain language of 968?
Well, I think the answer is that it is on a case-by-case basis. I don't think you can do it based upon the complaint. I don't think it's a issue for a motion to dismiss. But I do think when a court hears the totality of the circumstances, when a court hears everything that occurred, a court may very well find, yes, the application of this case law in this fact situation violates the revised code section. But I think the court can also say that no, the violation, based upon the facts and the totality of the circumstances, there is no violation of revised code 9.68. I think it is a case-by-case factual determination.
968, by its terms, says that any process, including citations and prosecutions, are declared null and void, preempted, superseded, and restricted if they threaten the possession, storage, or keeping of any firearm. How does this prosecution not fall within the realm of that language?
Well, I think it is based on the totality of the circumstances, and the court did not hear the totality of the circumstances. In this particular case, this defendant was on probation, and how the gun was found is that the probation, it's not in the record, but the probation officer was on the premises conducting a check. So the fact that this defendant could not possess, actually, I'm sorry, it's not the defendant, it's the defendant's spouse.
That may all be true, but this statute says that prosecutions may not occur. It's not intended to allow a trial to vet out the full circumstances. By its plain terms, it's intended to stop prosecutions.
If that's the court's understanding and that's the court's ruling, I understand that. That is not what I think the case law says. That is not what I think how the statute should be applied, and that's why I'm here saying that it has to be based on the totality of the circumstances, as many, many, many child endangering cases have held.
Is there any case law interpreting 968 that would support your reading of it?
I think this case is going to be the one. I have not, in doing the research for this case, nothing has been reported as of the time that I researched the brief. Don't know what's happened since the brief was filed. So that's the state's argument. I believe the trial court erred in granting the motion to dismiss. And
Let me ask one more question before you sit down. So the complaint in this case typed into the complaint and then filled out by hand, but the typed part specifies that the substantial risk was created by the defendant negligently storing or leaving a firearm. It tells what the firearm is in a manner that the defendant reasonably should have known that the child could gain access, et cetera. Okay? So that is actually the typed part of the complaint, and then the specifics are handwritten into it. So if we look at this, can we say that this complaint could be either Section A or Section B of the ordinance?
you're the judge, you can say whatever you want to say.
Well, okay.
But I will tell you that the portion of the complaint that you're referring to is placed there so that the weapon can be forfeited. The portion that you're referring to is not it's part of the factual allegations, but that's not something that I would say is an element that has to be proved at trial. But it is something that if the defendant is found guilty, then I would argue, based upon this, the weapon should be forfeited.
Well, counsel, following up on that question, because do you concede that the complaint itself does not specify that the charge is brought under subsection A or subsection B?
Well, I will tell you that the complaint does not say, does not type in A or B.
Fair,
I will tell
yes.
you that the language of the complaint create a substantial risk to the health and safety of a child clearly files under subsection A.
It tracks some of the language of subsection A.
Yes, ma'am.
But then, under this specification section, it defines the substantial risk as the negligent storing of a firearm. And that's the language of subsection B, right?
And it's also, yes, ma'am, that is correct, but I will tell you it's the language that's necessary to have the weapon forfeited. And I will tell you that there is case law that defines the substantial risk to what a substantial risk of harm to a child is. And I already know the court's position about that case law predating the revised code section. But it is case law that has not to this point been overruled, and it's certainly something that our officers should rely on in making their charging decisions.
And so is it accurate that to say that this complaint incorporates the language of both subsection A and subsection B?
I don't think so, but if that's what the court rules, then that's what the court rules.
All right, thank you.
You couldn't just proceed prior to B being found in conflict with 9.68. You couldn't just proceed under B. B doesn't
Correct.
set forth an offense.
No, B is a
It's a definition.
statute, yeah,
So
section,
you would always have to have proceeded under A.
correct.
Thank you.
Thank you.
Good morning, judges. Eric Larson on behalf of Ms. Watson. And I think we've already hit the nail on the head of where this is going. This is a case about guns and Cincinnati's efforts to create legislation that went beyond what the state of Ohio said a municipality was allowed to do. In all frankness, I never anticipated becoming a gun rights advocate in my practice, but here I am, and the law is the law.
Can I ask you a question, though?
Yes.
This kind of goes to what Judge Kinsley was asking. Could somebody be prosecuted under the state child endangering statute, which is basically the same language as Part A of the Cincinnati Municipal Code, for this offense?
For this offense, I believe they could.
Okay.
But the fact remains is they're not.
No, but
And
this
that's
goes
what
to
makes-
the idea of whether somebody can be prosecuted for leaving a loaded firearm near a 3-year-old in the bed under the state law.
I believe that they could be.
Okay?
But again, they're not charged under the revised code.
Why could they be?
Because the revised code of the state of Ohio, in terms of a child endangering, just lays out something that's actually quite similar to Section A.
Right.
That says if you put a child in danger in one way, form, or another, that you can be prosecuted for that. We have a tricky balance to make.
So then you concede that subsection A,
No.
as applied to a firearms offense,
No.
is,
Because it cannot be applied to a firearm. And that, we see oddly enough, in
Well,
a footnote written by
Well,
Judge
why is
Ray.
it different then? If the state statute can be applied to a firearm, then why can't the city statute be applied to or city ordinance be applied to a firearm?
Great question, and that is because the state statute is written broadly. This statute, this municipal ordinance, is written solely regarding guns. The title of it is about guns, and if we look at the facial versus personal, and forgive
But
me as
in
I
West,
flip.
we already said that subsection A creates no independent conflict with 968 because it doesn't reference firearms by its plain terms. So we
If we
didn't
look-
interpret the title.
It wasn't interpreted in West. It's addressed actually in a footnote in City of Cincinnati versus Ohio. I know that you didn't agree with that decision, Judge, and that's all now pending before the Supreme Court. But in reviewing that, if we look at footnote 2, it says that in West, we held that a single subsection of a Cincinnati ordinance conflicted with amended revised code 968 because it regulated firearms in a way not specifically provided for by state or federal law. Two other of the subsections of that ordinance did not violate amended RC 9.68 because one generally regulated child endangerment and did not relate to firearms. As it is applied here, the city, based upon their complaint, is attempting to apply it to firearms. In fact, if we go all the way back just to the motion to dismiss, the city's motion to
I
dismiss
guess I'm not
states-
understanding though, because what would be the difference if the state statute, which is general as to child endangerment, is applied to firearms, and this city ordinance, which is general as to child endangerment, is applied as to firearms?
Because the city ordinance cannot be applied to firearms.
But why can the state one be applied to firearms?
Because there isn't a 9.68 saying it can't.
But 9.68 does say that.
If there were, if state issues, are you telling me 9.68 applies to the state law as well?
It
And
applies
not just the
to
municipality?
any ordinance, regulation, any threat of citation, prosecution, or other legal
Well,
process.
then it can't be, and I misspoke. And I make, to add to that, clear that the city is attempting to do just that. If we look back at its motion to dismiss, they wrote specifically, at trial, the state will prove that she recklessly created a substantial risk to the health and safety by negligent storage of her gun. 9.68 says this can't do it. West says you can't do that.
Did you, well, I don't know if you were the counsel below, but did counsel below for the defendant raise an as-applied argument in the motion to dismiss?
I did.
That was you? Okay.
Yes.
So you did a facial and an as-applied challenge? Okay.
And counsel, is it your position that this specific complaint incorporates the language of both subsection A and subsection B?
I think it's crystal clear that it has section B in it in as much as it quotes section B in laying out the basis as for the complaint and the factual basis for the complaint.
And can you point me to that language?
Certainly. The complaint reads, starts off with, did create a substantial risk to the health and safety of a child by violating a duty of care, contrary to and in violation of section 915. Specification. In a manner or location in the defendant's residence such as the defendant knew or reasonably should have known that the child was able to gain access to a firearm. That is directly out of 915-3. The language is all boilerplate within that complaint.
So I believe, boiling down the city's argument, as I understand it, the city's position is that all it's attempting to do here is to enforce A, and that this case has nothing to do with B. Is that accurate?
I don't think that's accurate at all. It cannot, well, I think that is their position, but you can't on the one hand say, this has nothing to do with B, the section about guns, but we are going to prosecute them because of what they did with guns, which is directly identical to Section B, which has been found to be void.
I mean, the complaint contains B language from your perspective, right?
Clearly, it quotes directly from it.
All right, so is it your position then that this complaint falls within the West injunction?
I believe it does, yes.
So let's, hypothetically, if the city had passed the ordinance and it had only passed Section A and Section B never existed, okay? Let's just pretend that that was the case. Would we still be questioning whether having a loaded firearm under a pillow where a 3-year-old was sleeping was endangering the child?
I think the answer to that is whether we like it or not. That's what 9.68 says.
So your argument is 9.68 says that a municipality cannot have their own separate child endangerment law that they apply to somebody who had a gun.
Correct.
But the state, initially you had said.
Initially, I had
The
said.
state can, and I do think
and that-
9.68 says that except as provided by state law, so, you might be correct on that, but.
That's, yeah, I'll leave the final interpretation to you guys.
Right,
on that.
but
I
basically, you came in here saying, yes, the state of Ohio, under these facts, could prosecute somebody, but 9.68 says under these facts, the city cannot.
Correct.
So if it were a butcher knife instead of a gun, that would
I
be fine?
I would say that a butcher knife is not in 9.68.
All right?
Again, we don't have to like 9.68.
Didn't the state
it's weird.
amend, I'm not a 9.68 expert, but didn't the state amend 9.68 to include knives?
Oh, sorry.
I'm going to be frank, I do not know, Your Honor. I did not look at that issue.
It
I
did.
didn't anticipate that hypothetical.
I have it in front of me.
Okay, thank you. Yes, then yes. Since it is in 9.68, it is thereby limited.
Okay. Oh, you're right. It does have knives now.
And I frankly, I don't have much to add because the basis of my statement is you can't apply this statute to an action, or excuse me, this ordinance to an action involving firearms based on 9.68.
Counsel, what if the city were to have filed a generic complaint against your client, citing only the language of subsection A, and at trial proved the facts that are now alleged?
Under those circumstances, I think it would still be the same outcome in my mind.
That would be a Rule 29 type issue?
I think so. Even before that, though, because 9.68 still precludes a municipality from using a law to prosecute these kinds of cases.
But the complaint would then not be facially defective?
The complaint itself, it would not be facially defective, but it would be defective as applied to this individual because it's relying on the facts, things that would come out in such as a bill of particulars or something along those lines.
Is that an opportunity for the city to have its day in court, though? I mean, I hear Ms. Bishop saying that there should be some consideration of the totality of the circumstances and an opportunity to present evidence that might bring forth something new to the table.
Right, but and this is my notation that I had made, and I'm glad that you asked that, or I would have forgotten it. Totality of the circumstances isn't found anywhere in the statutes, period. It's not there. It's not a totality of circumstances. It is or it isn't. And in this manner here, under those circumstances, looking at 9.68, I likely would have filed a similar or some sort of motion following discovery because you can't apply it, this municipal code, to guns. And
Because
that's
it regulates storage.
Because it regulates storage, exactly. And that's, it's the plain language of 9.68, not a totality of circumstances. And to look upon a defendant with vagueness in a complaint and ask them to go to trial and a Rule 29, or to beyond a reasonable doubt under those circumstances, juggles the questions of, do I bring this to a jury, where I have to explain the complexities of a law like 9.68 that, frankly, as a lawyer, the first time I looked at it and tried to go through it was really complicated, and explaining it to a layman under those circumstances would be difficult. And presenting it to the bench and asking them to parse that out. I think I would do the very same thing, probably with slightly different crafting to it, but it would be the same kind of motion, because 9.68 is clear. And as the court has pointed out, all of the case law comes before 9.68 and its work. I understand what Ms. Bishop has said about citations to case law, but it's not that issue at this point. The issue is strictly, can the city prosecute someone for how they're storing a gun based on 9.68? And the answer is no, they cannot. State law says they can't. I don't have anything else. Thank you all very much.
And although I reserve time, I don't have any further argument, so unless the court has additional questions.
I mean, is the city prosecuting someone for how they're storing a gun?
In this case or in general?
In this case, is the city prosecuting somebody for how they're storing a gun?
No, the city's prosecuting someone based upon creating a substantial risk to the health and safety of a child.
Counsel, is it possible for the city to file cases like this simply using the language of subsection A?
Yes.
Thank you.
So if, for example, the defendant had the gun in a drawer that was short, low enough for the child to get rather than in the bed, would we be in a different situation? Because that would be a matter of storage as well.
Well, I don't think it's a matter of storage. I think it's a matter of creating a substantial risk to the health and safety of the child.
But it's the manner of storage that is creating that risk, correct?
I don't think it is, but if that's how the court interprets
Well,
it.
can you explain that then? Can you explain why you don't think that the manner of storage is creating the risk?
Well, because to me, the totality of the circumstances is what presents the risk to the child. So if the weapon is in a drawer in a room that child doesn't access, that's totally different than if the weapon is in a drawer that also has kids' games, candy for kids, and things that would create the substantial risk to the child.
It's a jury question. It's a fact finder question.
I think it's a question of fact, yes.
Yeah.
So, and that's why, and the other child endangering cases say this, the totality of the circumstances is important as to whether or not the location of the weapon created a substantial risk to the health and safety of the child.
Thank you.
Thank you.
Thank you for your arguments this morning. We will issue a timely written decision in the case. Enjoy the rest of your day. That concludes our docket for the morning.
Thank you.